The abortion ban legislation was passed in 2003 by the Congress and then signed into law by President Bush. As soon as it was signed into law, 3 lawsuits happened at the same time, one in New York, one in Nebraska, and one in San Francisco.
The 3 cases from San Francisco, Nebraska, and New York are winding their way through the appellate process. They'll go to the various circuit courts in San Francisco, New York, and Nebraska, and then perhaps the Supreme Court will take it. But to be honest, my guess is this won't make it to the Supreme Court because the Supreme Court has repeatedly struck down laws that don't make exceptions for, quote, the health of the mother.
All 3 courts have now come up with a ruling and each of the rulings separately have said that this bill is unconstitutional. And it is unconstitutional for 2 very important reasons. It's unconstitutional because it is written in such a broad way that it has the effect of banning common and often used abortion procedures and many different procedures, some as early as 12 to 15 weeks. And it's unconstitutional because there's no exception for the health of the mother.
The overwhelming medical evidence that we received in the Congress and we put in the legislation was that this is a rogue procedure that is never medically necessary and in fact is dangerous to women's health and therefore really falls outside of the Roe v. Wade prohibitions of limitations on abortions.
There is a huge loophole, and this is that the state can prohibit abortions in the 3rd trimester unless the abortion was being done for the woman's health. That's a huge term, and it's used politically all the time.
The health exception is really a bit of a red herring because it starts from a fundamentally false premise. Pregnancy is not an illness, and abortion is not a cure. So the entire way the argument is structured, that somehow women need to be protected from their children, sets mother and child apart from one another, and it makes people think that we have to choose one or the other. That's not natural, it's not correct, it's not accurate, it's not medically necessary.
People saying that the lack of a health exception is a loophole is really preposterous. And it is really why Congress ought not to be legislating medical affairs. Medical providers, physicians, know what is a health exception. And they're very clear about that, and the law has been clear about that.
The individuals who interpret what the health of the mother is the doctors performing the abortions who are given the financial gain of the procedure.
Roe versus Wade's evil twin, if you want to call it that, was Doe versus Bolton. It was a court decision done on exactly the same day as Roe versus Wade. And it defined the term health. Roe didn't define health. What did the word health mean? But Doe versus Bolton did define health. And health in that court decision means a woman's physical health. Well, nobody would have too much argument with that. Of course, they didn't say how physically unhealthy she'd have to be in that case. Her mental health, boy, now we're starting to get into some real subjective areas. Her economic health, and even her social health, whatever that means.
Whether mental health is an issue is certainly part of physical health, and I think our medical people would say mental and physical health cannot always be separated, nor should they be separated. And it is part of the reason why the American College of Obstetricians and Gynecologists are also against this ban, because once again, physicians, not Congress, know a health exception and know when it needs to be paid attention to.
There are thousands of abortions in this country that are performed on healthy mothers with healthy children. All a mother has to do, according to the constitutional law, is say that she doesn't want the baby and it will cause emotional or economic or familiar stress. That's it. Well, I mean, every baby, no matter what, is going to cause some stress. I mean, most of it is joy, but I'm sure there's some element of stress in having a child or doing anything in life. And so what basically has happened is that abortion is abortion on demand up until the moment of delivery. And these procedures are used overwhelmingly, 99+% on healthy mothers, healthy babies.
In the end, these health exceptions are so broad that essentially abortions can be done anytime during a pregnancy. That doesn't mean you'll have that a patient would have an easy time finding a doctor to do a very late-term abortion, but technically, with those technically those things can be legal as long as he certifies that this abortion is being done for the woman's health.
There was a tracking of these abortions in the state of Kansas. Every single abortion, there was, I think at the time, the year that I looked at was about 50 abortions. Every one was on healthy mothers, healthy children, and the issue and the reason for the abortion was, quote, mental health. You know, I understand it's stressful. I understand sometimes you decide you don't want a child, but when you're that late in pregnancy and these children feel pain, these children are you know, fully developed, look like you and me, not sort of a blob of tissue, if you will. And I think we have to look at our society and say if we want to continue to let this happen.
By trying to say that there's never a reason, which, by the way, all three courts said was also ridiculous, that the findings of Congress were, in fact, erroneous and inaccurate. So if physicians are faced with having to make a decision as to whether or not there's a threat to a woman's life or a significant threat to her health, I would trust physicians to make that decision much more than I would trust people in Congress.
The health exception for the mother is something that has been interpreted by the Supreme Court under Roe v. Wade and Doe v. Bolton as so broad as to include, quote, the psychological health of the mother and or her family. So essentially what that exception does is it eliminates the rule. It would allow abortions as they are currently at any point in the pregnancy, at any time the mother chooses, for any reason the mother chooses.
The legislation that has been proposed and put forward as so-called partial birth abortion legislation would in fact prohibit women from getting abortions during the second trimester, even during the first trimester, and certainly during the third trimester of pregnancy, even when there are serious health concerns that make an abortion necessary.
The Justice Department, under Attorney General Ashcroft, has said that it will in fact appeal and has put out a notice of appeal, which is a legal step in all three jurisdictions, and has actually filed the papers in the Nebraska case.